Thanks for coming. Strang and Jerry Buting. Should be questions now.
Good evening.
Good evening. There were enough of you who asked to talk with us. We thought it would make sense just to do it in a group. So thanks for sticking around.
You mentioned in the earlier in the evening that the documentary brought up lots of issues and problems with the criminal justice system. I'm a defense investigator by trade. I run a magazine for private investigators. We have our own perception issues. People don't tend to like private investigators.
Mm-hmm.
One of the things that I noticed in the documentary was the huge imbalance between the prosecution and the defense. The district attorney has the police department investigating for them. They usually have staff investigators working for them. The defense side usually has a lawyer, a couple of lawyers, maybe an investigator.
Right.
What kind of an impact could a good, solid criminal defense investigator provide to a defense team?
Well, I think they're essential in most cases, but they'll never duplicate a police department or replace a police department. We don't have the subpoena power. We can't get search warrants. And as you say, in a well-funded defense, you'll have one defense investigator, maybe two. If it's a corporate, defendant or target. So it's an irreplaceable role, and I think, many cases in which a defense investigator would be essential don't have a defense investigator, either because the public defender's office doesn't have the resources to provide that for every case, or it's a private case and the fee doesn't encompass enough to hire a private investigator, or sometimes the lawyer doesn't recognize the importance of defense investigation. So this is an area where even when we get it and we understand the need for an investigator, we're hampered by an asymmetry of authority and power that the defense investigation has as compared to the state investigation. Now, the justification for that is that the state bears the burden of proof in the end. But the reality, of course, is that most criminal cases can't be defended on simply, standing on reasonable doubt and hoping that the jury will give that life. For most criminal cases, you can and must offer a counter narrative to the prosecution's narrative, and that normally requires investigation.
It also, though, means an investigator, not like you saw from Mr. O'Kelly, somebody who's actually working for the defense and the defense function, not helping the prosecutor dig a deeper hole, as I think the federal judge commented in the Dassey decision.
And that was going to be my follow-up question. When I watched the documentary, when I saw Mike O'Kelly doing what he did,
shocking.
It's infuriating.
Yes.
How do you guys feel about him as the work he did?
We did not see that video, neither Dean or I, until the documentary came out. And my first thought was, oh, wait a minute, how did we not get this in discovery? And then I realized this was the defense investigator. So maybe it wasn't even turned over to the prosecution, but it wasn't generated by them. So, that was just a terribly shocking thing to see. And to me, when I saw a pre-printed form, which means it's used a lot, and how many other Brendan Dassey cases has that guy used this form where your only choice is, I'm sorry for what I did, or I'm not sorry for what I did. How about I didn't do it? It's not even an option for me. And that was, to me, just indefensible, unconscionable aspect of all the things that poor Brendan Dassey had to suffer through. So.
This was already asked before, but how does Dassey's overturned conviction affect Stephen Avery, if it does at all?
That's ultimately going to be up to his attorneys in terms of how they want to use it as a strategy. Directly, they didn't use Brendan Dassey's confession in Stephen Avery's trial. So the state may well argue, well, it shouldn't affect him at all because we didn't use that evidence. But in effect, they did. They used it in the press conference where the special prosecutor polluted the entire jury pool that we had to pick Stephen Avery's jury from. And the effect of that false and involuntary confession was very evident as we picked through the jury questionnaires where 129 of 130 people believed he was guilty, that Stephen Avery was guilty before they heard any evidence in court. And that was very clearly because of that involuntary coerced confession that the special prosecutor used to pollute the jury. So whether that will have an effect in Stephen Avery's latest efforts, you'll have to ask his current attorneys, but I think it had an impact.
How confident are you that Avery will ever be a free man again?
You know, we're not directly involved in representing him at this point, but I remain optimistic. You know, the difficulty he has that Brendan didn't have is that his appeals were over. So he has to, in order to get back into court, he has to have generally some sort of newly discovered evidence angle. And I was hopeful, I think I even said in the documentary at one point, I was hopeful that when this aired, that some people would come forward with new information, and then that is in fact what happened. Initially, when we were, before he had Kathleen Zellner's firm take on representation of him, we were getting all kinds of emails, you know, hundreds, well, several thousand eventually. And many of them with tips, both fact witnesses, people up in Wisconsin that knew something, and scientists who said, you know, there's a lot of improvements in science in the last 10 years, and there are different kinds of tests that can be done. So I'm optimistic that, you know, he does have good experience, very skilled attorneys now representing him, and that they're putting together a defense that's going to get him back in front of a court and that conviction reversed.
Can you talk a little bit about the funding disparity when you were talking about the cost of defenses versus prosecution?
Sure. Nationally or in Tennessee or?
Either.
The study I cited was a joint study of the ABA and the Tennessee Justice Project, if I remember the name of it correctly. It came out in 2007, but it concerned fiscal year 2006. So that's available if you want to look for it. Just, you know, the point of that was to say that the picture in Tennessee where the spending on the prosecution function exceeds spending on the indigent defense function by 2 or 3-fold. The point of that is that that's roughly true across the country, no matter where you look. And, you know, I understand that that's not a direct apples to apples comparison. First of all, there are some criminal defendants who can retain counsel, so it's not 100% of criminal defendants who become a taxpayer responsibility in defending. Second, it is of course true, as I said just a moment ago, that it's the state that bears the burden of proof, in theory at least, not the defense. The reality, though, is much more complicated in an adversarial system where jurors and judges expect to hear from both sides. They expect to hear two sides to a story, you know, as the common idiom goes. And it's hard to tell that second side when you're chronically underfunded. I'm not looking for anybody to cry a river about people charged with crimes in general. That's not what it's about. What it's about is our interest as citizens in the reliability of convictions that often result in years and years in prison, or occasionally, you know, the last Western democracy to be using the death penalty, to be using death as an implement of criminal justice. So we as citizens have a real stake in reliability, and you can't have one side always punching above its weight. You just can't.
Going back to Dassey, this is a big hindsight 2020, but given the current development, do you look back and wish that his confession had been used in the Avery trial outright, and that it could have been part of the evidence, or could have been part of grounds for appeal? Or I guess in general, is there situations where even though a co-defendant's confession is damaging, usually to another defendant, that it can be so flawed that it can actually be beneficial to the defense to have it in there?
Well, yeah, we actually thought that in fact, that was the case with the Brendan Dassey confessions, because first of all, the stories were inconsistent every time you talked to him. You know, he couldn't remember what he'd said because it never happened. You know, he didn't have a memory to draw on. And so from every time you talked to him, the story changed. And, but probably more to the point was we went through his confession carefully, and we had experts look at this, and we knew that the tactics that they were using were coercive, and to pick on a 16-year-old with learning disabilities and to put him through something like that. If the jury had seen that, it would have bolstered our argument that look at what lengths the prosecution is willing to go to try and get this man, Stephen Avery. And so in that instance, no matter what he said, given the way it was asked and the changes from one interview to the next, and the techniques that were used, and the false promises, and you can make it look however you want, we know it was all Stephen Avery's fault, on and on and on like that, we actually thought would have been beneficial.
I have a little bit different take on that, but not much. Irrespective of whether I would have preferred Brendan Dassey's statements to be introduced in Stephen Avery's trial, there would have been, in a sense, more structural honesty to Stephen Avery's trial had the state introduced those statements in evidence, or tried to, because they were in fact used. They were in fact brought to the attention of our jury, but 10 months before the trial started, and repackaged by a lawyer who's skilled in rhetoric or rhetorical speaking, repackaged from the inarticulate mumblings of a kid adopting suggestions from the police into an apparently coherent, gripping narrative as the prosecutor presented it in the press conference. And, you know, Wisconsin has 72 counties. There's not a one of them we could have gone to where this narrative from the prosecutor in his press conferences hadn't permeated most of the public, because all of the 7 media markets that overlap or exist in our state, all of them carried that. So we had a jury that had heard a recapitulation of that statement. They just hadn't heard it at trial or in the evidence.
As a follow-up, just a quick follow-up to that, how, on the flip side too, the court of public opinion, or the jury pool of Netflix viewers or whatever, how big a part do you think them seeing that story had in Brendan Dassey's current situation and his conviction?
I don't think there's any way to know that, at least if you're not Judge Duffin or working in his chambers. Certainly making a murderer is now part of the context of Brendan Dassey's case and Stephen Avery's case. It's part of the cultural context. And as I say, judges participate in our culture, just like you do and I do. But there's just no way for someone who's not this judge or working for this judge to know what, if at all, the impact was, or what impact, if any, the film had. Putting on as objective lenses as I possibly can, when I read that decision, I see a very well-written, careful, restrained thoughtful opinion that's factually dense and cited, for every factual assertion, there's a citation. I mean, I see good judicial work, irrespective of the outcome. And I guess one way Jerry and I might look at it as lawyers who've occasionally been in this position is, had we been representing, the client, and this decision been handed down in our case, and now we look at and say, all right, the state may appeal this, how are we going to do now that we have to defend and affect the judge? I'd be pretty happy as a lawyer if I had that opinion to defend on appeal. I think the judge, gave an opinion that just was really superb judicial work, outcome aside. So you'd feel good about saying, okay, I've got what I need to work with here in defending this judgment if the state appeals. Now that's a lawyer's reaction to it, but it's an honest reaction.
But it also was, all of those facts that he cites and over in the record, and the quotes that are taken there, that's also a product of very good lawyering by his post-conviction attorneys from Northwestern University Center on Wrongful Conviction of Youth. So Steve Drizzen and Laura Nyrider got all of those facts in the record after the fact, the things that weren't done before trial, some of it anyway, and nothing that's cited in the opinion is something that came from Making a Murderer.
How long have they been representing?
Since at least early in his direct appeal. I don't know
Probably
exactly when.
2008.
Probably 2008, but we're guessing at that. But they were post-conviction or appellate counsel, not trial counsel, and I don't think they got in immediately in the direct appeal, but they've had him for several years. Laura Nyrider, I think, was still in law school when she began working on Brendan Dassey's case. And she's since then gone to a large Chicago firm, left it, and become a clinical assistant professor at Northwestern University. So it's been a number of years they've been involved. And it is a product of good lawyering in part. I suspect that there was good lawyering by the Wisconsin Department of Justice, by the Attorney General's office on that too. 2 assistant attorneys general assigned, one of them a very senior criminal appeals person. And so, often when you see good judicial work as you did here, you're also seeing good lawyering on both sides that does tend to produce a better, more reliable outcome when the adversarial system really works in that way.
What effect, if any, do you think the decision could have retroactively to people's cases that are similar to Brandon's, presuming everything stands, that similar to his in the state, or possibly for other states to kind of take away and look at it?
The problem with involuntary confessions is that, or claims of involuntary confession, is they are so fact-bound. They are so fact-specific. And indeed, it's the mantra that the courts use is you have to consider the totality of the circumstances, which truly means that no one case is exactly like any next case. All the same, it's good to have a case for comparison, for later claimants. So it becomes one more case that can be used for factual comparison in the future, and it's an especially well-written, thoughtful, careful opinion.
This may be a question that goes more towards cinema than law, but we talked about visuals and the power of visuals and making people three-dimensional. What if the Averys had lived in a gated community? Have you ever kind of thought about whether the case would have caught on this way?
People often ask us, would it have had the same impact if Stephen Avery and Brendan Dassey were black? And the truth of the matter is probably not. And that's, that's a sad commentary on, what motivates the viewing public and what maybe Hollywood would find even interesting enough to put on the air. But in a lot of ways, this was sort of a wake-up call for white America. For once, they got to see the kinds of abuses that's been too easy to sort of just push aside and think, well, that just happens to the others, people not like me. Whereas here, yes, there is this big disparity in the socioeconomic class, and that's underpinning a lot of the history of Stephen Avery and the way he's been treated in the criminal justice system twice now. But it's probably easier for people to relate to someone like his family than it is to somebody in a gated community, although they may tangentially find it more entertaining perhaps to see, like in the old days of Dallas, Who Shot JR, had a big sort of soap opera kind of appeal. But when it comes to real crime and how people can relate to what goes on in their courthouses, I think it would not have been the same at all if this had not been.
I was sort of smiling, not because I thought your question was funny, just because empirically, just purely empirically now, Stephen Avery probably wouldn't have been charged or in prison at all had he lived in a gated community, just empirically. I mean, you have to look long and hard in America's state prisons to find a prisoner of any real means, of any wealth, or even, middle or upper middle class economic status. The really wealthy people being charged with a crime at all in this country is such a rare occurrence that we hear about almost every one of them. We hear about John DeLorean and Martha Stewart and O.J. Simpson, and now I assume Bill Cosby is a man of some money. But, you hear of Dennis Kozlowski, you hear about them. They make news. Robert Durst in the Jinx. And so in addition to what Jerry said, I think part of the spotlight that Making a Murderer and shows like it shine on our criminal justice system is on the role of class in the criminal justice system. And in a heterogeneous society, class, of course, gets linked pretty quickly to ethnicity, race, recent arrival as an immigrant. It gets linked to all those things, but there's an underlying role of class or socioeconomic status that's unmistakable empirically in our criminal justice system. The poor are the basic fodder of our courts.
We want to make sure to hear from everyone, so if you want to.
I want to ask, you talked about the prosecutor repackaging the narrative. Do you blame, and you talked about the media on stage earlier tonight, do you blame the media for not digging deeper into that repackaging from the prosecutor? Because we're all looking in radio, 30 seconds, TV or 2-minute package or what have you. Not a lot of people dug deeper.
At the time, I don't. Because at the time, the physical evidence that undermined and disproved much of that narrative wasn't available to the media. And my guess, I'm just guessing now, this may be unfair, but I'm guessing it's not. My guess is that if you had been at the press conference and said, well, Mr. Kratz, do you have any blood? Do you have any DNA? Do you have hair? Do you have anything, any trace evidence that supports that statement? He would have said, well, I can't comment on the evidence, or I can't disclose.
Someone did ask, and he said, well, no, we're not going to talk about that.
Right, we're not going to talk about that. And you wouldn't have been able to get it by a freedom of information request or an open records request, because there are exceptions, I think, in every state for open cases or open investigations. During the trial, once it became clear that the evidence not only failed to support, but affirmatively disproved critical elements of that story, I do think the media could have been more faithful to its function in presenting that to viewers. The facts were what they were at trial, or the evidence was what it was, and that evidence didn't leave any room for most of the narrative about Brendan Dassey's statement.
The other thing, just to follow up on that, after the trial, we introduced, in fact, we filed with the court a big, thick memorandum for sentencing purposes that included the transcripts of all of the Brendan Dassey interrogations, DVDs, copies of everything that you can now get, and all of that was available to the media. And one television station, one reporter dug into that. Everybody else ignored it completely. So, it's not like this is new information. 10 years ago, all this was out there. It was laid out in a very similar way to explain how these false promises were made there, and false friend, and the false information and coercive stuff that was presented to Brendan Dassey, but nobody in the media wanted to take it up and look at it.
We have time for one more question, Aaron. I don't think you guys.
Talk about just in general with regards to your guys' tour and with regards to how people are now viewing the criminal justice system in America. Where do you see it going forward, from here, and what do you see the next 10 years, 20 years down the road? That is the criminal justice system going to get any better in this country?
I think so. I mean, if I didn't think there was any hope, then I probably would have given up practicing law 35 years ago. It's been a long, hard battle, and I do think, though, that there's an opportunity, as we discussed tonight. This is the first time where we've got, presidential candidates on both parties talking about criminal justice reform. We still have a few intransigent people in Congress that are blocking any of the most basic reforms, but if people continue to show an interest in it and to hold their elected officials accountable, then I think we can reform the process a little bit at a time. There's all kinds of things that are happening now. Social media, the really sort of unusual stuff that's gone online after the fact here, with all of the documents and the Reddit threads and subthreads and outsourcing of criminal investigation, where there's thousands of people now going through and pouring through this case and all the evidence. It's going to be harder for law enforcement or prosecutors to hide what really happens in a case if people maintain the interest level that they have, and the true crime interest. It's a little harder to see how that can happen before trial because so much of the information is not available to the public. But the angst that the community of Manitowoc, Wisconsin is feeling right now, if they had known that this could happen to them ahead of time, maybe they wouldn't have allowed the kinds of stuff that happened there, and the violations of the conflicts of interest and the lies to the public about that. And maybe a lot of that stuff they would have been, the misdoers would have been chilled from doing if they had known they could be caught later and exposed to millions. And so, maybe that effect alone will have some, cause some improvement in the system.
I agree with Jerry that the change comes. It comes most slowly, I think, when it's left solely to the institutions that together compose the criminal justice system. There's a great deal of institutional inertia in the police, in the judiciary, in prosecutors' offices, and among the defense bar. But it does come in time. You do see gradual procedural improvement. You see it come more quickly when the public forces it on these institutions. So, for example, the arrival of body cameras, which are now rapidly being adopted by law enforcement agencies around the country. The arrival for that, I think, is entirely attributable to citizens simply picking up their smartphone and videotaping what they see happening. That's what's driven that change. You know, the technology has been there, and it's getting, you know, these institutions to adopt the technology and to work that into their budgets and to accept change. That has come very rapidly when pushed upon the system by the public. And that's part of why Jerry and I are out speaking. We're just two voices, but, you know, it's two more than have been speaking before. And we're trying to reach people, and I hope encourage people thoughtfully to pursue change and to demand change in whatever ways they're able to do that.
And what's the best way to do that, just as a follow-up, in the juvenile court system, where it's often veiled in the, under protection, of the victims, and for that matter, the defendants' names and all of that? What's the best way to go about to?
Well, but the worst of it doesn't happen to juveniles in the juvenile courts. The worst of it happens to juveniles when they're pushed into adult court, where their names aren't protected, and where court is open to anybody who wants to come. We've got, in Jerry's home county, we've got two girls who were 12 years old at the time they engaged in delusional acts designed to please Slender Man and stabbing a classmate who, thank God, lived. 12 years old when they were charged. And they're in adult court in Wisconsin, and the judge and now the Court of Appeals has refused to move them back into juvenile court. Serious mental health problems for at least one, and probably both, 12 years old at the time, but they're in adult court. So their names are public, their faces are public, the media has access to all of that. So it's in fact not as hidden anymore when the worst excesses of our harsh treatment of juveniles occur.
That's all we have time for, folks. Thank you.
All right.
Thank you.
Thank you.
Thank you. Glad you could accommodate us together.
Oh, thank you.
Thank you so much.